The halls of the United States Capitol recently became the stage for a profound constitutional confrontation that strikes at the very heart of the American separation of powers. Senator John Kennedy of Louisiana led a rigorous interrogation of Robert Luther regarding the legal foundations of an investigation orchestrated by Special Counsel Jack Smith. This inquiry focused on the unprecedented acquisition of communication records belonging to sitting members of the United States Senate through various telecommunications giants. The gravity of the situation stems from the potential circumvention of established federal laws designed to shield legislative deliberations from executive overreach. Kennedy and his colleagues articulated a compelling argument that both the Department of Justice and private entities like Verizon failed their civic duties. The controversy centers on whether Special Counsel Jack Smith and Judge James Boasberg disregarded the constitutional immunity that governs congressional interactions with the public. Historically, the speech or debate clause serves as a bulwark against the executive branch using its investigative powers to intimidate or obstruct the legislative process. By bypassing the notification requirements typically afforded to the subjects of subpoenas, the government may have eroded a fundamental pillar of democratic governance. The senators argued that such secrecy prevents lawmakers from filing motions to quash subpoenas, which would otherwise protect sensitive constituent data. This lack of transparency has sparked a firestorm regarding the standard operating procedures of federal prosecutors when dealing with a co-equal branch of government. A central point of contention in this legislative drama is the disparate reaction of major telecommunications providers to these high-stakes federal demands for private data. While certain companies reportedly complied with the subpoenas without exhausting legal remedies, others like AT&T allegedly chose a path of resistance based on legal principle. This divergence highlights a critical gap in corporate responsibility and the protection of consumer privacy when faced with aggressive federal inquiries. The senators expressed profound disappointment that multi-billion-dollar corporations would surrender sensitive legislative records without insisting on a higher threshold of judicial review. Such compliance is viewed by critics not merely as a business decision but as a failure to uphold the constitutional rights of their users. The role of the judiciary, specifically the actions of Judge James Boasberg, has come under intense scrutiny for authorizing these sweeping data collection efforts. Critics argue that the court should have acted as a neutral arbiter, ensuring that any request for congressional records met the strictest legal standards. Instead, the perception among several senators is that the court may have facilitated an executive fishing expedition that bypassed traditional checks and balances. This perceived judicial negligence has fueled calls for a deeper investigation into the conduct of the federal bench in these sensitive matters. The possibility of impeachment proceedings or formal censures has been floated as a means of restoring the integrity of the judicial process. The implications of this standoff extend far beyond the immediate parties involved, touching upon the future of political neutrality within the Department of Justice. If the executive branch can secretly monitor the communications of its political rivals in Congress, the concept of a fair and balanced government is jeopardized. The hearing served as a public demand for accountability from both corporate executives and high-ranking federal officials who handled this sensitive data. It raised the haunting question of whether the tools of national security and criminal justice are being repurposed for partisan advantage. The tension in the room was palpable as the senators demanded to know why the usual protocols for legislative privilege were so easily discarded. The debate also touched upon the technical aspects of how metadata and electronic footprints are categorized under existing federal privacy statutes and telecommunications laws. Lawmakers emphasized that the digital age requires a more robust interpretation of old laws to prevent the exploitation of loopholes by overzealous prosecutors. They argued that the mere fact that information is held by a third-party provider does not strip it of its constitutional protections. This legal theory, often debated in the context of the Fourth Amendment, takes on a new urgency when the targets are elected representatives. The potential for a constitutional crisis looms if the executive branch can effectively blindside the legislature by targeting their digital service providers directly. Furthermore, the hearing illuminated the internal dynamics of the Special Counsel's office and its interpretation of the scope of its investigative mandate. Jack Smith's team has maintained that their actions are within the bounds of law and necessary for the completion of their assigned tasks. However, the aggressive nature of these subpoenas suggests a shift in how the Department of Justice views its relationship with the legislative branch. This shift is seen by many as a departure from decades of established protocol that favored inter-branch cooperation over litigation. The Senator's refusal to accept these explanations points to a growing rift that could define the legal landscape for years to come. The testimony provided by Robert Luther was particularly illuminating as it forced a public reckoning with the mechanics of federal oversight and compliance. Each question from the committee sought to peel back the layers of bureaucracy that often shield government actions from public and legislative scrutiny. The focus remained steadfast on the necessity of judicial transparency and the preservation of the rights of those being investigated. It was clear from the line of questioning that the senators believe a fundamental line has been crossed in the pursuit of political targets. The call for accountability is not just about the past, but about setting a standard that prevents future abuses of power. The testimony from various corporate entities revealed a complex web of legal interpretations that often prioritize risk mitigation over constitutional defense. For many providers, the threat of federal sanctions or legal repercussions often outweighs the desire to protect the privacy of even the most high-profile clients. This creates a dangerous environment where the government can leverage corporate fear to gain access to information that would be otherwise protected. The senators challenged this culture of compliance, suggesting that companies have a moral and legal obligation to act as a check on government power. The debate underscores the need for new legislation that clarifies the duties of tech companies when faced with subpoenas for legislative data. As the hearing progressed, the focus shifted toward the potential for long-term damage to the trust between the American people and their government institutions. When the public witnesses such fierce disagreements between the branches of government, it can lead to a sense of disillusionment and cynicism. The senators were acutely aware of this, framing their arguments not just as a defense of their own records, but as a defense of the democratic system. They argued that if the privacy of a United States senator can be so easily compromised, the privacy of the average citizen is even more precarious. This broader narrative helped to connect the technical legal arguments to the everyday concerns of the American electorate. The intersection of technology and law remains one of the most volatile areas of modern governance, especially when it involves the surveillance of political figures. The ability of the Special Counsel to cast such a wide net without immediate pushback from the judiciary remains a point of intense legal scholarship. This case will likely serve as a cornerstone for future debates regarding the limits of prosecutorial power in the 21st century. Scholars are already analyzing the transcript to determine how these events might influence future Supreme Court decisions on legislative privilege. The outcome of this specific controversy could rewrite the rules of engagement for every federal investigation involving a member of Congress. The strategic use of subpoenas to gather intelligence on political opponents has a long and troubled history, but the digital dimension adds a new layer of complexity. Unlike physical documents, digital records are easily searchable, vast in scope, and often provide a more intimate look into the daily operations of an office. The senators pointed out that this vastness makes the need for a filter team or a judicial master even more critical. Without such safeguards, the executive branch gains a significant informational advantage that can be used to influence legislative outcomes. This imbalance is exactly what the founders of the Republic sought to avoid when they drafted the Constitution. The role of public opinion in this matter cannot be understated. as both sides sought to win the narrative battle through their opening statements and questioning. The special counsel supporters often frame these investigations as necessary for the rule of law and the pursuit of justice without fear or favor. Conversely, the critics see a targeted campaign designed to hamper the activities of specific political actors through legal harassment. This polarization makes it difficult to reach a consensus on what constitutes a fair and legal investigation in a highly charged atmosphere. The hearing, therefore, was as much a political theater as it was a legal proceeding, aimed at a national audience. Throughout the session, the rhetoric used by Senator Kennedy was designed to highlight the absurdity of a system that allows secret surveillance of its own lawmakers. His use of sharp metaphors and direct challenges to the witnesses underscored his belief that the Department of Justice has lost its way. This style of questioning is a hallmark of his approach to oversight, often forcing witnesses to answer for the broader implications of their specific actions. By focusing on the common sense aspect of the law, he attempted to make the complex constitutional issues accessible to a wider public. This strategy ensures that the debate remains a topic of national conversation rather than just a footnote in a legal journal. The potential for impeachment investigations against those who authorize these subpoenas remains a potent threat hanging over the Department of Justice. While such an extreme measure is rarely used, the level of anger expressed by the senators suggests that it is not off the table. They argue that if the laws of the land are to have any meaning, there must be severe consequences for those who violate them from within the government. This serves as a warning to other officials that their actions will be scrutinized and that they cannot hide behind the veil of executive privilege. The accountability movement within the Senate is gaining momentum, fueled by each new revelation about the scope of the data collection. As we look toward the next phase of this constitutional struggle, the focus will likely turn toward the internal communications of the Department of Justice itself. Lawmakers are eager to see the internal memos and legal justifications that were used to greenlight the subpoenas in the first place. This transparency is seen as the only way to determine whether the actions were taken in good faith or as part of a broader political strategy. The refusal to provide these documents would only deepen the suspicion that there is something to hide within the halls of the Justice Department. The stage is set for a prolonged legal battle over the very nature of executive transparency and legislative oversight. The technical intricacies of the subpoenas issued to telecommunications providers reveal a sophisticated strategy of data harvesting that bypasses traditional Fourth Amendment protections. When federal prosecutors seek non-content information such as call logs and location data, they often rely on the Stored Communications Act, which has lower hurdles than a search warrant. However, the senators contended that when the targets are members of a coordinate branch of government, these standard tools become instruments of constitutional subversion. The sheer volume of metadata requested allows for a comprehensive reconstruction of a lawmaker's professional and personal network, effectively mapping their legislative strategy. This level of intrusion, conducted without the knowledge of the affected parties, creates a chilling effect on the freedom of association and political expression. The debate intensified as it became clear that the data sought was not merely incidental but central to the political activities of the senators. Central to the tension is the role of Verizon and other providers who allegedly facilitated this access without mounting a vigorous legal defense on behalf of their subscribers. Senator Kennedy's sharp inquiry suggested that these corporations may have prioritized their regulatory relationship with the executive branch over their contractual obligations to customers. The argument is that a subpoena of this magnitude, involving the highest levels of government, should have triggered an immediate escalation to the company's general counsel. Instead, the perception of a quiet, rubber-stamp compliance has led to a crisis of confidence in how private industry handles sensitive government data. If the guardians of the digital gates do not resist overreach, then the constitutional protections afforded to citizens and lawmakers alike become functionally obsolete. The senators demanded to know if any internal alarms were raised, or if the process was treated as a routine administrative matter. The allegations regarding AT&T's refusal to comply provide a fascinating counter-narrative that highlights the possibility of corporate defiance based on legal merit. If one provider found the legal basis for the subpoenas lacking, it raises serious questions about the judgment of those who chose to cooperate. This discrepancy suggests that the legal demands were not as airtight as the special counsel's office might have claimed during the application process. The senators utilized this contrast to paint a picture of a Justice Department that shops for the most compliant path to achieve its investigative goals. This forum shopping for cooperation undermines the uniformity of federal law and places an unfair burden on companies that choose to stand by constitutional principles. The hearing aimed to uncover whether AT&T faced any retaliatory pressure for its decision to prioritize the legal rights of the legislators involved. Legal scholars watching the proceedings have noted that the lack of a notice and opportunity to be heard is the most glaring procedural deficiency in this saga. Under normal circumstances, the target of a subpoena can move to quash it if they believe it is overbroad, privileged, or issued in bad faith. By keeping the subpoenas secret through non-disclosure orders, the government effectively stripped the senators of their ability to defend their legislative privilege in court. This maneuver ensures that the only parties involved in the process are the prosecutor, a compliant judge, and a potentially intimidated corporation. The senators argued that this creates an ex-parte environment where the adversarial system, the bedrock of American law, is completely circumvented. Such a process does not just target individuals. It targets the institutional integrity of the Senate itself by allowing the executive to spy on its operations. The psychological impact of these investigations on the legislative process cannot be measured in mere data points or legal filings. When senators are aware that their communications are subject to secret seizure, they may become hesitant to engage in the very debates and negotiations that the Constitution protects. This hesitancy can lead to a less effective legislature, where the fear of executive retaliation dictates the boundaries of political discourse. The hearing served as a platform to voice these concerns, framing the issue as a fight for the future of independent lawmaking in America. Kennedy's interrogation of Robert Luther was not just about past actions, but about preventing a permanent shift in the balance of power. The goal was to re-establish a clear zone where legislators can perform their duties without the specter of a surveillance state looming over them. The intersection of the special counsel's mandate and the broader political landscape adds a layer of complexity that makes neutral analysis difficult but necessary. Jack Smith's investigation into the events surrounding the 2020 election and its aftermath is inherently polarizing, given the high-profile nature of the individuals involved. However, the procedural questions raised in the hearing transcend partisan loyalty, touching on the fundamental rights of any person holding office, regardless of their party. The senators emphasized that today's targets might be Republicans, but tomorrow's could just as easily be Democrats if these precedents are allowed to stand. This universal appeal to the rule of law was a calculated effort to build a broader coalition against executive overreach. The focus remained on the process rather than the politics, insisting that a justice's blind approach must apply to the investigators as well as the investigated. As the discussion turned toward the potential for legislative reform, the idea of a Legislative Privilege Act began to take shape within the committee's rhetoric. Such a law would explicitly require the executive branch to provide notice to Congress before subpoenaing the records of its members or staff. This would codify the protections that the senators argue are already implicit in the Constitution but have been ignored by the current administration. By creating a statutory barrier, Congress could ensure that any future special counsel would have to face a transparent judicial challenge before accessing sensitive data. The hearing acted as a catalyst for this legislative movement, providing the evidence of abuse needed to justify such a significant change in federal law. It also highlighted the need for more oversight of how judges handle non-disclosure orders in cases involving political figures. The role of the filter team or taint team within the Department of Justice also came under fire during the intense questioning. These teams are supposed to review seized material to ensure that privileged information is not turned over to the primary prosecution team. However, the senators expressed deep skepticism about the ability of the DOJ to effectively police itself, especially in a politically charged environment. They argued that a government-run filter is essentially no filter at all, as it still allows the executive branch to possess and review legislative secrets. The preference, as expressed by the committee, would be for a court-appointed special master who is entirely independent of the Department of Justice. This demand for independence is a direct response to what the senators perceive as a lack of impartiality within the current investigative framework. The debate also touched on the global implications of how the United States treats the privacy of its top-level government officials. If the world's leading democracy cannot protect the confidential communications of its lawmakers, it sets a troubling example for emerging democracies and authoritarian regimes alike. The senators argued that by eroding these protections at home, the U.S. loses its moral authority to advocate for the rule of law abroad. This broader perspective was used to underscore the high stakes of the hearing, moving the conversation from a domestic dispute to a matter of international significance. The integrity of American institutions is a key component of its national power, and that integrity is directly tied to the strength of its constitutional safeguards. The hearing was a public demonstration that those safeguards are currently under extreme pressure. In the final hours of this segment of the hearing, the focus returned to the individual accountability of those who signed off on the subpoenas. Robert Luther was pressed on whether he believed the actions taken were consistent with the highest standards of professional ethics for an attorney. While the responses were measured and couched in legal jargon, the underlying tension was clear. The Senate was not going to let this issue fade away. The threat of future subpoenas for the investigators themselves was hinted at, suggesting a watch-the-watchers approach to oversight. This cyclical nature of investigation and counter-investigation is a hallmark of the current era of American politics, where the legal system is often the primary battlefield. The session concluded with a sense that this was merely the opening chapter in a much longer and more consequential conflict. The historical context of legislative immunity provides a necessary backdrop to understand the profound frustration voiced by the senators during these proceedings. For centuries, the principle that lawmakers must be free from executive harassment has been a cornerstone of parliamentary and later, American democratic traditions. The Supreme Court has historically interpreted the speech or debate clause broadly to ensure that the legislative process remains robust and uninhibited by the threat of prosecution. In landmark cases such as United States v. Brewster and Gravel v. United States, the judiciary affirmed that protections extend beyond mere speeches to all integral legislative acts. The current controversy, however, suggests a modern trend where these protections are being narrowed by a digital-first approach to law enforcement. By focusing on metadata held by third parties, the government claims a loophole that the Founding Fathers could never have anticipated in their era. The senators pointed to the 2006 FBI raid on Representative William Jefferson's office as a critical turning point in the history of interbranch relations. In that instance, the D.C. Circuit Court ruled that the executive branch's search of legislative files violated the constitutional protections afforded to the House of Representatives. That ruling established that the mere preview of privileged documents by executive agents constitutes a violation, regardless of whether the material is used in court. Kennedy and his colleagues argued that the secret subpoenaing of phone records is functionally equivalent to a physical raid, only more insidious because of its invisibility. They contended that if a physical filing cabinet is protected, then a digital cloud containing the same sensitive communications must also be off-limits. This comparison was used to highlight the perceived inconsistency in how the Department of Justice applies constitutional law in the 21st century. Critics of the Special Counsel's approach argue that the use of non-disclosure orders has created a shadow docket of investigative actions that escape public and legislative scrutiny. These orders, often referred to as gag orders, prevent telecommunications companies from informing their customers, even United States senators, that their data has been seized. The hearing revealed a deep-seated concern that the judiciary has become too comfortable with granting these orders without requiring a high burden of proof. The senators argued that a gag order should be the exception, reserved for cases involving immediate physical danger or flight risk, not political investigations. By making secrecy the default setting, the government effectively silences any potential opposition before a legal challenge can even be formulated. This systemic lack of transparency was a major theme throughout the afternoon's intense questioning of the witnesses. The discussion also delved into the specific types of data harvested, ranging from basic subscriber information to sophisticated cell site location information and detailed call logs. While the government may argue that metadata is not content, the senators countered that metadata provides a roadmap of a lawmaker's every move and interaction. Knowing who a senator speaks to, for how long, and from where they are calling can reveal sensitive legislative negotiations and whistleblower identities. This information is often more valuable to a political opponent than the actual substance of the conversations themselves, as it exposes the underlying infrastructure of political power. The committee emphasized that the protection of sources and methods is just as important for the legislature as it is for the intelligence community. Without the ability to communicate confidentially with constituents and colleagues, the very function of a representative democracy is severely compromised. Furthermore, the hearing touched upon the potential for mission creep within the Special Counsel's office, where an investigation into one event expands into a broad dragnet. The senators questioned whether the search for specific evidence regarding the 2020 election had transformed into a general surveillance program of political rivals. This concern is rooted in the fear that once a prosecutor has access to a senator's phone records, they can look for unrelated crimes or leverage. Such a scenario would turn the Department of Justice into a political weapon, a fear that has been echoed by various civil liberties groups across the political spectrum. The hearing sought to establish clear boundaries for how far a special counsel can go before their investigation becomes a fishing expedition. The tension in the room reflected the high stakes of allowing such an expansion of prosecutorial power to go unchecked. The role of the private sector as a buffer between the state and the individual was another recurring theme that sparked heated exchanges between the committee and the witnesses. The senators argued that when companies like Verizon receive a subpoena for a lawmaker's records, they have a duty to recognize the unique legal status of the target. They suggested that these corporations should have specialized legal teams trained to identify and challenge requests that infringe upon constitutional privileges. The fact that this did not happen in several instances was framed as a dereliction of duty toward the principles of the American legal system. The senators pushed for a commitment from corporate leaders to implement more rigorous review processes for all government requests involving the legislative branch. This shift would place the burden of proof back on the government, where it traditionally belongs in a free society. As the hearing moved into its middle phase, the focus turned toward the internal guidelines of the Department of Justice, specifically the Justice Manual. These guidelines are supposed to provide a framework for sensitive investigations, often requiring high-level approval for subpoenas of journalists or political figures. The senators questioned whether Jack Smith's team adhered to the spirit of these guidelines, or if they found ways to bypass the spirit of the law while following the letter. The ambiguity of these internal policies was highlighted as a major flaw that allows for personal or political bias to influence investigative decisions. There were calls for the Justice Manual to be updated with clear, mandatory protocols for any investigation involving a member of Congress. This would ensure that no single prosecutor has the power to unilaterally bridge the gap between the executive and legislative branches. The psychological toll on the staff and families of the targeted senators was also briefly addressed, adding a human element to the technical legal debate. The knowledge that one's personal life and professional contacts are being scrutinized by federal investigators can be incredibly distressing and disruptive. The senators argued that this pressure is often the point of such investigations, to distract and demoralize those who are in a position to challenge the executive branch. This lawfare tactic, as some describe it, uses the legal system to achieve what cannot be won through the democratic process or open debate. By bringing these issues to light, the committee hoped to strip away the clinical veneer of the investigation and show its real-world impact. The emotional gravity of the testimony underscored the belief that the current path is unsustainable for a healthy democracy. The concept of equal justice under law was invoked by both sides, but with vastly different interpretations of what that means in practice. For the investigators, it means that no one, including a United States senator, is above the law and that all must be subject to the same investigative tools. For the senators, it means that the law must be applied in a way that respects the constitutional structure of the government and the unique protections afforded to each branch. They argued that equal justice is not a license for the executive to ignore the separation of powers or to treat a co-equal branch as a subordinate entity. This philosophical divide is at the heart of many of the current legal battles in Washington and shows no signs of being resolved. The hearing served as a microcosm of this larger national struggle over the definition and application of justice. In summary of this section, the proceedings highlighted a growing consensus among many lawmakers that the current system of federal oversight is failing to prevent significant abuses of power. The combination of digital surveillance, judicial deference, and corporate compliance has created an environment where constitutional privileges can be easily bypassed. The senators' aggressive questioning of Robert Luther and others was a desperate attempt to reassert legislative authority in an age of executive dominance. As the hearing prepared to enter its final stages, the focus shifted toward the specific remedies and legislative actions that could be taken to restore the balance of power. The evidence presented so far suggests that the issues raised are not just technical errors, but systemic flaws that require a fundamental shift in how the government operates. The discourse then transitioned toward the structural remedies necessary to rectify the perceived imbalance between the executive's investigative reach and the legislature's right to autonomy. Senator Kennedy and his colleagues began to outline a framework for what they termed a legislative restoration, a series of statutory guardrails designed to prevent future incursions. This proposed reform focuses on the mandatory involvement of a neutral third party, such as a specialized magistrate, in every instance where congressional data is requested. The senators argued that the current reliance on district judges, who may be overwhelmed by the volume of federal warrants, has led to a dangerous level of judicial passivity. By creating a dedicated office for legislative privilege, Congress could ensure that every subpoena is vetted for constitutional compliance before any data is transferred. This would effectively move the gatekeeping function away from the Department of Justice and back into a transparent judicial forum. Central to this reform movement is the demand for a fundamental rewrite of the Electronic Communications Privacy Act to account for the unique status of elected officials. The senators emphasized that the distinction between content and metadata has become a legal fiction used to justify warrantless surveillance in the digital age. They proposed that any request for the metadata of a sitting member of Congress should be subject to the same probable cause standard as a physical search warrant. This would close the loophole that currently allows prosecutors to obtain vast swaths of personal information with a mere showing of relevance to an ongoing investigation. By raising the legal bar, the legislature aims to ensure that only the most critical and well-justified inquiries can penetrate the veil of legislative privilege. This shift would represent the most significant change to federal privacy law in several decades, reflecting the realities of modern telecommunications. The hearing also explored the potential for creating a congressional general counsel with expanded powers to intervene in any legal proceeding involving a member's records. Currently, the protection of privilege often falls on the individual senator and their personal legal team, who may not be notified until after the fact. Under the proposed model, telecommunications companies would be legally required to notify this central congressional office whenever a subpoena for a member is received. This would create a centralized and robust defense mechanism that does not depend on the whims of individual corporate legal departments. The senators argued that the institutional rights of the Senate should not be left in the hands of private entities whose primary loyalty is to their shareholders. A centralized legal defense would ensure that the separation of powers is defended with the full weight of the legislative branch's authority. The role of the Special Counsel's office in responding to these criticisms remained a point of intense interest, despite their general policy of not commenting on ongoing investigations. Through various legal filings and public statements, the office has maintained that it operates with the utmost integrity and within the bounds of all applicable laws. They argue that any attempt to create special carve-outs for politicians would undermine the principle that no one is above the law. This tension between the need for investigative efficacy and the need for constitutional protection remains the central conflict of the entire hearing. The senators countered that protecting the legislative process is not about protecting individuals from criminal liability, but about protecting the democratic system from executive intimidation. This fundamental disagreement on the nature of equal justice continues to drive the wedge between the two branches of government. As the committee delved deeper into the technicalities of the subpoenas, they also addressed the role of the rule of specialty and how it applies to domestic investigations. Traditionally used in international extradition, the principle suggests that evidence gathered for one purpose should not be used for another without specific authorization. The senators expressed concern that the special counsel may be using broad subpoenas to gather information that is then shared with other divisions of the Justice Department. This cross-pollination of data could lead to a permanent surveillance state where the records of political rivals are stored in a centralized database for future use. To combat this, they proposed strict data destruction requirements for any information that is found to be irrelevant to the specific investigation at hand. This would prevent the government from building a permanent dossier on lawmakers through the incremental accumulation of metadata. The testimony from the Department of Justice officials, while often evasive, provided a glimpse into the internal culture that permits such aggressive investigative tactics. There appears to be a prevailing view within certain circles of federal law enforcement that the exigency of high-profile cases justifies the bypass of traditional protocols. The senators were quick to rebuke this mentality, arguing that the importance of a case should heighten, not lower, the requirement for constitutional compliance. They pointed out that history is littered with examples of emergency powers being used to erode civil liberties and dismantle democratic checks and balances. The hearing functioned as a necessary corrective, reminding the executive branch that its power is delegated and limited by the will of the people and the Constitution. The demand for a return to normalcy in interbranch relations was a recurring sentiment among both Republican and Democratic members of the committee. The discussion also touched upon the responsibility of the Federal Communications Commission in regulating how providers handle sensitive government requests for data. Some lawmakers argued that the FCC should implement new rules that mandate greater transparency and reporting requirements for telecommunications companies. This would allow the public and Congress to see the sheer scale of government data requests and identify any patterns of abuse or overreach. By bringing the regulatory power of the FCC into the fold, the legislature could create an additional layer of oversight that operates outside the criminal justice system. The goal is to move away from a model of secret compliance toward one of public accountability and legal rigor. This holistic approach shows that the Senate is looking for solutions across all sectors of government to protect its institutional integrity. Furthermore, the hearing raised the possibility of using the power of the purse to limit the scope of the special counsel's activities. By attaching specific conditions to the funding of the Department of Justice, Congress can effectively mandate the protections it seeks through the legislative process. This would involve prohibiting the use of federal funds to execute subpoenas on members of Congress without prior notification and judicial review. While a blunt instrument, the appropriations process is often the most effective way for the legislature to exert control over a defiant executive branch. The senators signaled that they are prepared to use every tool at their disposal to ensure that the constitutional rights of the legislature are respected. This financial leverage serves as a potent reminder of the Senate's role in the American system of government. The session also featured a significant amount of debate regarding the ethical obligations of the attorneys involved in drafting and serving these controversial subpoenas. The American Bar Association's rules on candor toward the tribunal were frequently cited, with senators questioning if the prosecutors were fully transparent with the judges. If a prosecutor fails to mention the potential for legislative privilege when applying for a warrant or subpoena, they may be in violation of their professional duties. The committee hinted that they might refer certain individuals to state bar associations for disciplinary review if evidence of intentional concealment is found. This would bring a personal level of accountability to the officials involved, moving the consequences beyond the realm of institutional policy. It underscores the belief that individual actors must be held responsible for the systemic failures of their organizations. As this segment of the discussion concluded, the focus shifted toward the long-term impact of these events on the stability of American democracy. The recurring theme was that the current trajectory, if left unchecked, would lead to a hollowed-out legislature that exists at the pleasure of the executive. The senators emphasized that their fight is not just for themselves, but for the future of the republic and the preservation of a balanced government. They called on the public to pay close attention to these procedural battles, as they are the true front lines of the fight for liberty. The evidence presented so far has painted a troubling picture of a government in conflict with itself, struggling to define the limits of power in a digital world. The final phase of the hearing promised to bring even more scrutiny to the actions of the Special Counsel and the future of the Department of Justice. The final deliberations of this historic hearing shifted from the technicalities of the law to the enduring legacy of the American constitutional experiment. Senator Kennedy's concluding remarks underscored a profound anxiety that the precedents being set today will become the standard for every future administration, regardless of its ideological leaning. The core of the argument remained that a government capable of secretly surveilling its own lawmakers is a government that has strayed far from its founding principles. This is not merely a dispute over phone records. It is a fundamental test of whether the separation of powers can survive the transition into an era of total digital visibility. The senators warned that if the legislative branch does not reassert its authority now, it risks becoming a subordinate office rather than a co-equal power. This sense of urgency permeated the room as the witnesses were given their final opportunities to justify the actions of the executive branch. The impact on the relationship between the citizenry and their elected representatives was a significant point of reflection as the session drew to a close. If constituents believe that their communications with the senator's office are being monitored by federal agents, they may lose the courage to report government waste, fraud, or abuse. This would effectively destroy the whistleblower pipeline that is essential for congressional oversight of the executive branch and its vast bureaucracy. The senators argued that the special counsel's actions have created a vacuum of trust that will take decades to refill, damaging the very fabric of democratic participation. This broader social cost is often overlooked in legal filings but remained a central concern for the lawmakers who must answer to the public. They emphasized that a representative cannot truly represent a people if the privacy of that relationship is subject to the whims of a prosecutor. Looking ahead, the potential for a Supreme Court showdown seems almost inevitable as these two branches of government continue their collision course. Legal experts suggest that the High Court may eventually be forced to define exactly how the speech or debate clause applies to digital metadata and third-party records. This would be a landmark decision, potentially as significant as those defining executive privilege during the Watergate era or the limits of legislative immunity during the Vietnam War. The outcome would establish a definitive boundary for federal investigations in the 21st century, providing much-needed clarity for both prosecutors and legislators. Until such a ruling occurs, the country remains in a state of constitutional limbo, where the rules are written through conflict rather than consensus. The hearing served as the necessary catalyst to move these questions from the halls of Congress to the highest levels of the judiciary. The role of the media and public discourse in shaping the narrative around these investigations was also scrutinized during the final hours of testimony. Both sides acknowledged that the court of public opinion is often as influential as a court of law in determining the survival of political institutions. The senators expressed concern that the selective leaking of investigation details can be used to damage reputations long before a single charge is ever filed in a courtroom. This trial by headline is exacerbated when the underlying data collection is done in secret, leaving the targets with no way to defend themselves in real time. The demand for a more transparent and ethical approach to investigative communications was a plea for a return to civility in the national political arena. They argued that the integrity of the process is just as important as the outcome of the investigation itself. In the final analysis, the interrogation of Robert Luther and the critique of Jack Smith's methods reveal a deep-seated fragility in the American system of checks and balances. The ease with which the executive branch was able to access the private records of its political counterparts suggests that the parchment barriers of the Constitution require active and constant defense. The hearing was a vivid demonstration of that defense in action, characterized by a fierce and uncompromising commitment to institutional independence. While the immediate legal battles may continue for years, the intellectual and political foundations for a legislative counteroffensive have been firmly established. The senators made it clear that they would not be silent spectators to the erosion of their constitutional rights or the rights of the American people. This resolve signals a new era of congressional assertiveness that will likely define the political landscape for the foreseeable future. The legacy of this confrontation will likely be measured by the legislative reforms that follow in its wake and the change in corporate behavior among tech giants. If companies like Verizon and AT&T adopt more rigorous standards for government data requests, it will represent a significant victory for privacy and the rule of law. If Congress successfully passes new protections for legislative data, it will have built a digital wall that mirrors the physical protections of the past. These changes would ensure that the checks and balances designed in the 18th century remain functional and effective in the 21st. The hearing was not just a post-mortem of a specific investigation, but a blueprint for a more resilient and transparent government structure. It served as a reminder that in a democracy, no one branch of government should ever be allowed to operate in the shadows without accountability. As the gavel fell to end the proceedings, the tension between the participants remained, a testament to the gravity of the issues discussed. The questions raised by Senator Kennedy and his colleagues will continue to echo through the corridors of power, demanding answers that go beyond mere legal jargon. The search for a balance between national security, criminal justice, and constitutional liberty remains the great challenge of our time. This hearing was a significant step toward addressing that challenge, stripping away the secrecy and forcing a public conversation on the limits of power. The American people are now left to judge whether their government is serving their interests or the interests of those who seek to control the levers of power. The fight for the soul of the Constitution continues, with this hearing serving as a critical and dramatic chapter in that ongoing story. The enduring image of the day was one of a co-equal branch of government standing its ground against what it perceives as an existential threat from within. Whether one views the Special Counsel's actions as a necessary pursuit of justice or a dangerous overreach, the need for clear rules and transparency is undeniable. The testimony provided a rare glimpse into the mechanics of power and the hidden struggles that define the American state. It reminded all observers that the price of liberty is eternal vigilance, especially when it comes to the actions of those who wield the power of the law. As the nation moves forward, the lessons learned in this committee room will undoubtedly shape the future of American governance and the preservation of its most cherished ideals. The final word has yet to be written, but the lines of battle have been clearly drawn for all to see.